people who came to see the proceedings. We have sat until late. We shall render our ruling on Thursday at 2:30. Thursday is which date? A day after tomorrow, 31st at 2:30.
My lords, perhaps I need your guidance because we had indicated in the morning that we have an application for contempt of court.
Mr. Ndegwa, listen to the instructions and directions of court. We will give a ruling on this matter on Thursday, the 31st at 2:30. After that, we'll provide a way forward for any other matter. Thank you.
I am okay.
Please sit down. Yes, shall we see you on Thursday? Because the initial stage did not affect the functioning of the board. And there was a subsequent resentment because he had been nominated by two organizations. And the distinction here is that the position of the Deputy President is in a unique position as defined by Articles 130 and 131 of the Constitution, and therefore that case would not apply. There are many board members, about 8. This is a single position. Does not apply. As distinguished, my lord, as the impeachment of the Deputy President under Article 145 and the impeachment of a governor under Article 181 and Section 33 of the County Government Act, which is statutorily underpinned. Very distinguishable. All the cases they have cited are irrelevant on governors. The impeachment of a Deputy President is unique and is final under 145(7) because it is constitutionally underpinned and not statutorily underpinned. You can't object or finish. That's all.
My Lord, with tremendous respect to the court, we have had the opposition from the
court looks, the court does not accept a situation in which one is, of course, this issue that you are saying, that is saying there is no comeback from impeachment and all this, and that we proceed and swear. My Lord, if that were to be the case, then it would mean that impeachment is not the legitimate subject matter of this honorable court. Yet we have had the decisions that they have read themselves from the Supreme Court on the issues of impeachment. My Lord, Mr. Mudomi, you can call my friend, came with these interesting arguments that on the issues of jurisdiction. My Lord, these issues of jurisdiction is an interesting one, as you will see it in a minute. My Lord, the first impeachment case that appeared before a 3-judge bench was in Kerugoya. Kerugoya seems to favor a lot of impeachment stuff. And it related from the Embu cases. I don't know whether Professor Ugenda was there. It is important to say this with regard to that I actually made the precise argument that my learned friend Mr. Mubobi made about whether
impeachment of the president, because my submission was not that impeachment is generally non-justiciable. Even the authority cited it was about the impeachment of the president, whether that is justiciable.
I'll come to that in a minute. But the point I want to make, for purposes of the argument, the authorities there, for purposes of the argument, those precise arguments were made. There is actually no distinction when you look at the impeachment for governor under 181, how it is carried out in the release the one of the president. But one of the significant position that I wish to make from that case is this, that subsequent thereto, all courts from Court of Appeal to Supreme Court have taken the position that it was the desire of the Kenyan people that nothing shall be beyond the reach of the court for purposes of giving redress. And that is the basis upon which we have been proceeding. I will end it up there and come to what is more comfortable with. Jurisdiction with regard to purported ouster of the jurisdiction of this court with regard to impeachment of the president. My Lord, jurisdiction is actually not given in the manner that they are suggesting. My Lord, even for purposes of the governor, which he says is different, there is no provision under Article, I believe it's 181, that says, or 182, let me just confirm. Yes, my Lord, for purposes of the removal of county government under 181, the issue is, none of those procedures actually say that after you are done with impeachment, you will go to the high court.
May I help Parliament friend, as you do in Parliament? The impeachment under...
Professor, this is not Parliament. So, and he has not sought to help. Please sit down.
I know that tactic. But my Lord, the point I'm making is that even for purposes of Article 181 and 182 of the Constitution, there is nowhere that those provisions say that when you are done with impeachment at the Senate, you will go to the High Court. But nonetheless, people have been going to the High Court on account of jurisdiction as set out in Article 165 of the Constitution, the jurisdictions of the High Court. And therefore, my Lord, this requirement that, there is no provisions for going to court, it is neither here nor there. That is not the design of the Constitution. That question of jurisdiction has been settled by specific provisions of the Constitution. My Lord, what about these issues that you needed to go to the Supreme Court? My Lord, for purposes of the jurisdictions of the Supreme Court, it has been settled very clearly. I believe it is under Article 163, sub-Article 3, and it is settled in a manner that it says in very, very conclusive terms. This is 163. I believe it is 2. It is actually 3 and 4. They completely settle what is within the jurisdiction of the Supreme Court. Their argument that you cannot arrogate jurisdiction would actually come into play in this particular manner if this court were to make a finding that this matter ought to go before the Supreme Court. Because effectively, you would be amending Article 163, 3 and 4 of the Constitution as to the jurisdiction of the Supreme Court. But my Lord, where you find comfort is that the jurisdictions of the High Court, and that's why it is a court of original civil and whatever and criminal jurisdiction, is that the High Court has jurisdictions in everything unless the Constitution says otherwise. And to deal with that, when we come to the Senate, the moment, my Lord, you say the Senate was sitting in a quasi-judicial capacity, it is a design of the Constitution that any person who sits in a quasi-judicial capacity, there is a right to go to the High Court. There is no law in this country, not one, in which any person who sits in a quasi-judicial capacity, there is no remedy to go to the High Court by way of appeal, by way of Article 23, or any other manner. So that issue of jurisdiction is neither here nor there from the plain reading of the Constitution itself. So the other cases of Nixon, all those, they would be neither here nor there.
Dr. Ogada also addressed this, but what is your view on the submissions by Dr. Kenkuli about the constitutional history of that issue?
That's very interesting. I think I should say something. I was just giving myself additional pressure. My Lord, for purposes of that history, and incidentally, as a young lawyer, I was involved in all this process, courtesy of Muite, Orengo, and Dr. Gibson Kamal Kuria, so I can speak in past knowledge of some of these issues. My Lord, this Boma's draft constitution, you actually find it very interesting. We cannot go deeply into it. But the issue that is important to note is that under the BOM, the duty, the standing orders and in the Constitution, as a presiding officer in the National Assembly or in the Senate, the Speaker, there is a duty of impartiality. That is where anything you read about the Speaker, they talk about that. The duty of impartiality for purposes of the Speaker. For purposes of both Speakers, my Lord, they made the rules of impeachment. Those rules are the subject matter of what is going on. How you will carry out public participation, the calls that were made, is it going to be plenary, is it going to be committee? The most important one being, you could have held these proceedings until Sunday, you decided to read the rules, to allow people to vote on issue of rights. My Lord, my knowledge of and Article 27 of the Constitution, matters of rights are not subjected to votes. Yet that is what happened at the Senate. So that's an issue that we shall be talking about when we come to the hearing of the petition. So the Speaker is not a nobody. The Speaker, for purposes of these proceedings as they happen, all those speakers, they made consequential decisions that have had really serious implications in the matters that is before you. Mr. Bumbo, my learned colleague, he says very many things. You wonder what to choose, what to leave. One of the issues that he said that is when it was of Article 73(1) of the Constitution. That, of course, will be the case when he reaches the end of the road in these proceedings. End of the road will be Supreme Court, I am sure. But as of now, that issue does not arise. My Lord, as regards the issue of Article 148, 149, I think we have said a lot about it, except, my Lord, when it is alleged that public participation under Article 149 is not required. My Lord, the issue is this. The Constitution is clear that from Article 10, it says whenever you are interpreting or applying the law, the values and principles in Article 10, which includes public participation, shall apply. What that means, if the Parliament is carrying out a constitutional duty, of the Constitution requiring public participation is deleted from the I hope this information will serve its purpose.
I think you did answer Senator Council's question.
That decision will actually reverberate through all cases that touch on public participation. It's earth-shattering, and we are happy that God has brought it at this time to us. So God is on our side.
But I wonder now whether it is who was talking about Roscoe Powell. Somebody was talking about Roscoe Powell. But I agree with Roscoe Powell, one of my favorite legal philosophers, when he talked